Well, welcome, friends. It's an honor to have you all with us today. I'm Casey Gwynn, the president of Alliance for Hope International, and the co-founder of the Training Institute on Strangulation Prevention with Gail Strack, who has really led this effort nationally for more than 25 years. And we are very happy to have you with us today and to be joined by some great lecturers and trainers as well. We have quite a number of folks that are still going to be joining us, so we want to encourage you to use the chat as you come in. Just click on panelists and attendees to let us know who you are and where you're from. And of course, you can use the Q&A feature. This is a total of an hour-and-a-half webinar, so it's going to move very fast, but we are very honored to have many judges joining and other court personnel and others that practice in the court system around these cases of near and non-fatal strangulation assault. So thank you for being with us today. You'll see with each of us, there are quotes on the screen. My quote that pops up is related to my journey in this. When Gail Strack first started researching the so-called choking cases back in the 1990s, I didn't get it. I was a prosecutor handling felony and misdemeanor domestic violence and sexual assault, child abuse cases, and did not get it at all. Over a period of years, as I started learning more and more, however, I became fascinated by the difference between men who strangle women and men who might punch, kick, or slap women, but never provide pressure to their neck, never go after their neck. And you'll see my quote represented on the screen. I do believe that men who strangle women are the most dangerous men on the planet. Those of you who have seen any of our research know that we have published research on the relationship between stranglers and men who ultimately kill women, between stranglers and men who kill police officers in this country, between stranglers and mass shooters in this country. There is without a doubt a significant difference between those who go after the neck of a human being in an intimate violence situation or a sexual assault situation and those who might use other types of violence. We're also honored today to have Gail Strack with us. I'm going to let Gail just welcome everybody. She really is our leader in this work, and we're honored to follow her leadership at the Training Institute on Strangulation Prevention.
Well, thank you, Casey. That was a very nice introduction. But as you know, I always believe we can get a lot done when we work together, and it's the power of we. So I want to thank you for supporting this effort and also helping us. And that's what this is all about. I just feel like I have a very grateful heart this morning, and I just want to share my gratitude for all of you who are joining us today. We have over 600 people registered, and I know a lot of people register and then save it for a better day to join the presentation. So I'm also very grateful to our entire national advisory and faculty team. Today we are over 100 strong with our medical committee, our legal committee, and also our advocacy committee. And it just makes me feel so proud that we have so many dedicated professionals who are willing to think with us, be peer reviewers, and make sure that we produce the most thoughtful comments and resources and training that we can possibly come up with. And my passion point is to really focus on the survivors. When they seek help, we need to be ready to help them. And if we can't help them, we need to figure out how to improve our system. So for me, it's about accountability to survivors and always being willing to do a better job as we continue to learn. So Casey, back to you.
We are also very honored to have with us Judge Lee Chitwood from Virginia. And I'll let Judge Chitwood just say hello and tell you a little bit about his background as we get started. He is an attendee and a graduate of our 4-day course at the Training Institute on Strangulation Prevention. We have judges, prosecutors, defense attorneys, civil attorneys, lots of folks join us. But Judge Chitwood, thanks for being with us today and helping to provide some perspective from the bench on the handling of these complex cases.
Casey, thank you. Folks, I'm Lee Chitwood. I'm a juvenile and domestic relations district court judge from Pulaski, Virginia. I want to talk about 3 things today during our session. I want to talk about a little bit of my thoughts on bond. I want to talk about a strangulation bench card that I created for judges and other folks in this field. And then finally, I want to talk about another bench card that I created to use when folks, mainly ladies, come in and ask to dissolve their protective orders. My quote there is pretty short, but I really feel like we are in a crisis situation. And Gail and Casey and the Institute are doing a fantastic job getting this information out, but we need to spread it to everyone in this field, and especially to the judges who do this kind of work. But thank you for having me.
Thanks, Judge. We appreciate you joining us. We're also honored to have Jim Henderson with us. Jim Henderson served for many years as a probation officer in Michigan and is now running a batterers intervention program and does a lot of consulting work with us and others around accountability and processes for monitoring those who have harmed others, particularly an expert in this area, having gone through our 4-day course and now teaching for us at the Training Institute on Strangulation Prevention. So Jim, I'll just let you say hello real quick as we get started here. Oh, you got a barker. You got a barker.
I don't know. Hey, please. I apologize. Hey, my name's Jim. I'm so honored to be here, and I apologize for the dog who's getting excited. Someone must be driving by. I'm absolutely so blessed that you're here, because when I think about all the opportunities for trainings that we have available to us now, and all the ways you could be spending your time, that you are going to take an hour and a half of your day to come spend it with us and really learn about some of the most dangerous offenders that we can work with. You know, the amazing thing that the Institute does is they work so well with training police how to do a good investigation, training prosecutors how to prosecute, really looking at advocacy and medical treatment. But then if we don't hold these men accountable, if we don't really insist on change, victims are going to fall by the wayside. They're not going to participate in a criminal justice system that won't protect them. Why would they? I would not want to anger a man who's potentially going to kill me if no one's going to protect me, if no one's going to hold him accountable, if no one's going to give me hope. So this chapter, this little piece that we're allowed to talk to about today, I feel so honored to be a part of and to be here with you. As a child who grew up in domestic violence, who called the police again and again and again, and was in and out of the foster care system, the system's failure to hold my mom's assailant accountable forced us to go underground and not engage in the system. We learned not to trust you. And then you might call us uncooperative or non-participating or whatever label you want to give us. But really, you needed to look in the mirror and say, what are you doing to make families not willing to engage? And so I hope that I'm excited to talk to you today, and I'm excited about the information that you're going to have. And thank you, Casey and Gail and everyone, for allowing me to be a part of this.
Thanks, Jim. Thanks for joining us today. And of course, in the Zoom world, Gail's got construction going on in her home. Jim's got a barking dog. You never know what might come up as we go through our time together today. There's a quick agenda. We're going to talk a little bit about our recent published survey on the views of survivors of domestic violence, including many strangulation assault survivors. Then we're going to talk about bail considerations. Judge Chitwood's going to talk a little bit about his reflections from the bench. We're going to talk about protection orders and risk assessment tools, sentencing considerations, and we're going to wrap up talking a little about the importance of advocacy, including advocacy for survivors in the court system itself, and a little bit about the science of hope, which is so central to this as we wrap up today. We are going to just ask you to use the chat feature if you're game to tell us if you're a judge or if you're an advocate or a police officer or a prosecutor or a civil attorney. What challenges are you currently facing in court? What are you seeing going on in court in these cases, whether you're seeing cases filed or not, whether you're seeing bail being set or bond being set, low bails, maybe bond without any bail at all. But we'd love to have a little sense of what you're seeing around the country. We obviously keep our finger on that pulse, but it'll also inform our dialogue today as we go to have you share a little bit. What are the challenges in court? What are the frustrations? What are the issues? Thanks for using the chat, by the way, to just let us know who you are. Please click on panelists and attendees when you use the chat so everybody can see what you're including there. And that'll help us also be informed as we go on the things that you're particularly interested in all of this. As we kind of dive into this topic of court considerations, I really want to kind of set a little bit of context around all of this, particularly around the views of survivors. We're at a fascinating time in this country with the focus on racial justice issues, with the discussion about the role of the criminal justice system in addressing intimate partner violence. Obviously, a lot of progressive social change folks talking about somehow abolishing law enforcement or somehow trying to reduce the use of the carceral system because of its disparate impacts on communities of color. Real issues around structural and systemic racism that are real things that exist in the culture. Real issues around police abuses that have certainly been front and center since the murder of George Floyd, for sure. But we also want to make sure that we're listening to the voices of survivors. So last summer, really, we made a decision to reach out to survivors. We oversee family justice centers across the United States. Family justice centers are wraparound services model where we have all the services for victims of child abuse, sexual assault, domestic violence, elder abuse, trafficking, often under one roof. Our goal is that survivors get to come one place, which is what they always say they want. They wish they could go one place where we have cops and prosecutors and system-based advocates and community advocates and doctors and nurses and electronic filing processes with the courts and video teleconferencing with the courts. In some countries, we actually have courtrooms in family justice centers around the world. But we reached out to our survivors, said, we'd like to know your thoughts about this discussion about criminal justice reform and bail reform, and so many forces that are kind of pummeling the criminal justice system right now. And I want to share that with you as we begin today. I think it's important to know that our survivors don't represent all survivors of domestic violence in America. They certainly are a bit of a different population. Many of them have received wraparound services. You can see the majority of them are female. Family justice services come to men and women. We serve members of the LGBTQ community as well. But the majority that responded to our survey were women. The majority were also women of color. That responded. A majority of them had actually received services in a family justice center. Nearly 90% said those services were really beneficial in reaching their goals in life. And obviously a significant percentage believe that the family justice center model is a way to improve outcomes for survivors. So I share that with you because I don't think our survivors represent all domestic violence victims, those calling the national hotline, those going to a shelter but never calling the police, those never accessing wraparound services but going to a single siloed agency. But important survey that we did with 153 domestic violence survivors. And I want to show you what we asked them. First, we asked them about their actual experiences with law enforcement. We wanted to be very clear with them that we wanted to hear if they had positive experiences or negative experiences with law enforcement. Can we go to the next slide, please? And you'll see on this slide that overall it was a mixed bag, and it's always a mixed bag. If we ask the same experience of survivors in the court system, some would have positive experiences in the courts, some would have negative. If we ask positive and negative in dealing with prosecutors' offices, some would have positive, some would have negative experiences. What we wanted you to see was that there are both. There are law enforcement officers that do a great job interacting with survivors and law enforcement officers that don't do such a good job interacting with survivors. The differences between survivors of color and white survivors as far as negative and positive experiences, those differences are not statistically significant. But what was really interesting is that bottom one. There was a significant divergence between white survivors and survivors of color in talking about their reflections on whether the criminal justice system should be less of a focus and intervening around violence and abuse. Should we be thinking about alternatives? Should we be thinking about other ways that we can address intimate partner violence and not have the criminal justice system be the primary response? And you can see pretty clearly, even though a majority of survivors of color still said no to that question, there is a substantial minority of survivors of color who said we do support efforts to reduce. But overall, both with white survivors and survivors of color, the answer was no. They still want the criminal justice system involved. Then you'll see on the next slide some other key questions we asked. Do you think law enforcement should continue to respond to domestic violence as a priority one call? When you call the police, do you want them to treat that as priority one, the top call that law enforcement addresses? And look at this response. Overwhelmingly, almost 100% of survivors said yes. When we call 911, we want an immediate response. We asked if they thought advocates or other members of the community, like mental health professionals, should be coming with the police as opposed to just law enforcement officers coming alone. Look at that. The large majority of everybody, almost 100%, and the highest number being women of color, said yes, we would love law enforcement to come with advocates, to have a multidisciplinary kind of a response. Should offenders be allowed to avoid convictions through diversion programs? Overwhelming majorities of our survivors said no. They don't want criminal offenders who have harmed them to avoid accountability. And then finally, supporting bail reform efforts to allow offenders to get out of jail more quickly. Low bail, simple bond conditions, no bail, just let them out. Overwhelmingly, survivors said no. So when you're hearing these voices saying, we got to let everybody out of jail, they shouldn't be getting arrested and going to jail, it's very clear from our research, those are not the voices of our survivors. Our survivors are saying, no, we don't support these bail reform efforts. We believe that when they go to jail, they should stay in jail if they're dangerous offenders. And so that's going to be part of our conversation today. And as we go, is listen to the rights of victims, listen to the voices of survivors. Don't just listen to one group of people advocating for a particular position on bail reform or on criminal justice reform at the expense of survivors of violence and abuse. And then the last question we asked was really this question of, what do you think reform should look like? And the last one is particularly interesting. If we can go to the next slide, please. The last one really was this comment about what should we change? And the number one answer of our survivors was not abolishing the police or defunding the police or getting rid of prisons and jails in America. Their number one response was, we want police officers working with others. We don't want cops siloed working alone, prosecutors siloed working alone, courts siloed working alone. We want everybody working together, collaborative models. No great surprise, because our survivors are connected to family justice centers, wraparound services models in 43 different states. But I think it's still important information. They also felt law enforcement needed much more training on explicit and implicit bias. And they wanted to make sure that training didn't just happen after they get a badge and a gun. They wanted to make sure it happens before they get a badge and a gun, to know whether they've got misogynistic tendencies, to know whether or not they've dealt with violence and abuse in their own personal lives in an inappropriate way. They want that screening on biases around racism or around other kinds of biases before they become a police officer. But as far as taking money away from law enforcement, as far as abolishing the police, that was not the answer of our survivors. So we share that information because it's good context for the conversation that's going on in this country right now around domestic violence and criminal justice reform and bail reform. I do want to highlight at allianceforhope.com, if you click on our resource library, you will find a piece that I posted not long after the murder of George Floyd, in which we talked about this issue of bail reform and this push that people shouldn't be going to jail anymore, or that we should be letting people out of jail, or we should stop using the criminal justice system to intervene in domestic violence. I encourage you to read that piece and then listen to that recording. There's important information in that for you. We think the bail reform conversation is an important one. Nobody should be going to jail in this country because of the color of their skin or the size of their bank account. Nobody should be staying in jail because of the color of their skin or the size of their bank account. But on the other side, nobody should be getting out of jail simply because of the color of their skin or the size of their bank account. Nobody should get to avoid all jail or custody simply because of the color of their skin or the size of their bank account. We believe public safety and the dangerousness of certain types of offenders has to be in the mix. in the conversation about these issues. And as you'll see as we go today, I'm going to have Gail talk about this in just a minute. We are seeing a massive surge in homicides in this country, and we are seeing people getting out of jail for crimes that were very dangerous and very predictive of future violence that then go on to kill after they've been let out of jail on low bail or no bail at all, with just simply some bond conditions. And of course, the dangerousness of those folks was basically ignored by court systems. Whether or not judges were up against certain new rules on bail reform and bond conditions, or the pressure was simply significant to not put people in jail. And we're seeing those powerful forces both around reform, and we're seeing it around COVID-19. Many less people being prosecuted for strangulation right now in this country, even though our shelters and our family justice centers are saying that strangulation has skyrocketed out of the pandemic, that there are much higher levels of violence going on in intimate partner violence situations in the pandemic world and the post-pandemic world that we're in. So that's just some framing as we dive in today to our discussion. And I'm going to turn it over, I think, to Gail now to talk a little bit about this. She's been tracking these issues of this balancing between rights of defendants and victim safety issues. And I think we'll just give you a quick scan of what she's been seeing around the country.
Thank you, Casey, for giving us that context, because this is not an easy subject and this is very complicated. I've been doing this work for a number of years, starting in the late 1900s as a defense attorney, also working in county council, focusing on child abuse, domestic violence, sexual assault issues for many years, also being a prosecutor, being elected or selected as the director of the San Diego Family Justice Center, and of course now working with Casey at Alliance for Hope International, focusing our attention on the most dangerous individuals and trying to keep victims safe as much as we possibly can through family justice centers. So I share that with you as I now talk about this subject, which has become really near and dear to my heart, because both rights matter, but we've got to balance it. And I became involved with this issue back in 2018, not because I wanted to, but I felt I had to. And I also feel that I should have jumped in much earlier. And one of my pitches today will be all of us to continue to focus on this issue, to talk about this issue, for all of us to try to be at the table so intelligent, informed decisions can be made about this very complicated issue. But it was back in 2018 when we were headed to Fort Worth, Texas, for our annual Family Justice Center conference, and I have Google alerts. I am going to admit now that I have an obsession about a lot of issues, and Google alerts kind of feed that obsession to try to get as much information as possible, in addition to reviewing the statutes and reviewing the case law and talking to professionals that are on the front lines to really be on the pulse of what's going on. But as we were headed to Fort Worth, Texas, this Google alert came out about a mother and a daughter who had been strangled to death. And those Google alerts just break your heart the minute you read the heading. And as I was reading that heading even further, I realized that there was this history of domestic violence before she was killed and her daughter was killed. She was killed by her abuser, who had previously been charged with a felony strangulation that ended up being reduced to a misdemeanor because the prosecutor perceived the victim to be uncooperative. Now, when it comes to uncooperative, Casey and I and our entire team will challenge everybody to replace that word uncooperative with the word terrified, concerned, fearful. And we're going to be talking about that perception later, because now there is a science behind why victims will recant or minimize because they are fearful. And as Casey said, when it comes to the stranglers, we know now, based on everything that we've learned, that the stranglers are the most dangerous perpetrators on this planet. And in this particular case, what brought my attention was not only had he been previously strangled, and we minimized that case by reducing it to a misdemeanor, but he was also out on bail for yet another strangulation and also trying to run her off the road by assaulting her with her vehicle. There was death threats. It was a very serious case. And I go, oh my gosh, how could this happen? That very week, I also found out about a police officer who had been killed responding and as part of his job, where they were executing a warrant for an individual's arrest while he was out on bond, not only for domestic violence and strangulation, but a long list of other crimes. What was heartbreaking to learn, because I ended up following this case, is that this officer, Officer Gannon, just 6 months before he was killed, he responded to a call on domestic violence handling a strangulation case, was involved in the investigation and the arrest of that offender, and was coming back to this residence 6 months later because despite all of the bail bonds that had been posted, he would not return to court, so they were bringing him back to court. He was there with the team, including his dog, and as they were searching for him in the home, they could not find him in the residence, but suspected that he was in the attic. The dog ended up going into the attic and being shot, and then Officer Gannon also followed pursuit and ended up being shot and killed. And initially there was this tremendous outpouring and also anger, especially toward judges. And I was thinking like, well, wait a minute, judges usually follow what their bail statute requires. They usually follow their bail schedule. And it was at this time when I looked at both of these cases that were absolutely heartbreaking that I realized, oh my gosh, we should have been involved in this bail discussion from the very beginning. So I threw myself in, and we have thrown ourselves in to try to understand all of the issues that are happening. I have to tell you that since I've been tracking this, there are so many cases that it's even hard for me to track under my Google search, which includes while out on bail, while out on bond, where there's a warrant for an arrest. And those are the cases that do make the media, and we all know that there are many cases that never gets to a news story. But I'm going to give you the fast forward version, because if I went through each and every homicide that I have identified just through my Google searches, we would be here for literally for hours, because by my calculation it is happening somewhere once every 10 days, sometimes more often than that. But as I fast forward from 2018, I'm going to jump to 2020, and I saw in the chat that Texas has a problem, and at least Texas is trying to address it by bringing public awareness to this issue and trying to address it by changing some of the laws that exist currently. But in August of 2020, there was a report that was done highlighting the fact that murders were increasing in Harris County as a result of people being let out of jail, out on bond, only to commit additional crimes and also murders. At that time, they had identified at least 5 victims of domestic violence, and from what I can tell, most of them had that history of domestic violence, including strangulation. Then you kind of fast forward by October 2020, victims themselves, oh my gosh, they were outraged what was happening. They were the ones, and this is the first time I have seen this, where victims themselves were holding a press conference to bring this attention to the courts and to the public that they do not think this is right, they are not feeling safe, that they do, much like our survey that we conducted with survivors from family justice centers, that they didn't want them to get out of jail. All of us that do this work know when victims leave, that is a very dangerous time for them. We also know over the years that victim safety begins at the time of arrest, and that bail hearing is critical, that the court get as much information as possible. Well, I'm just going to be sharing a couple just to give you a sense of what I've been collecting. So you get to January, man strangles victim to death while out on bond for attacking her and another girlfriend. And there was that prior strangulation. Then you have February 16th, while out on bond for strangulation and violations of protection orders. A victim is killed. April 2021, while out on bond for sexual assault and strangulation, he ends up killing his stepdaughter, his ex-wife, and also his stepdaughter's boyfriend. and this was a police officer who had pending charges. On April, now we have a 10th-month-old that's killed, and this one really struck me because they had 2 prior domestic violence cases, one involving strangulation, and the victim was perceived to be uncooperative again, so the case was dropped, and then you fast forward and now you have a 10-month-old child who is killed. Now you get to April, husband kills wife and her friend. We had the chance most recently to work with our friends in Delaware and work with the judge and the court and others who attended our training. And while this occurred, there was a strangulation case pending. Delaware now is looking to see what they can do to improve their bail response. June 12, 2021, we have another case while out on bail. A pregnant woman is stabbed in front of her child. And I'm just focusing on cases of domestic violence or cases where there has been a very documented, well-known history that this person poses a danger to the victim and or to the public. And just before we started this webinar, I decided to look at my little Google search again and found that on July 16th, just like days ago, while out on 7 bonds, he gets arrested, released, arrested, released, arrested, released. He is now in jail for $8 million for killing his girlfriend and also shooting and wounding his 1-year-old child. And this just goes on and on and on. I'm getting to the point now where it's almost impossible for me to even keep up and maintain my PowerPoint, where I've been trying to keep track of this. And as many of you know that have been to our presentations before, we are sounding the alarm. We're sounding the alarm for people to pay attention to what's happening, to these discussions that are being held in your county, in your jurisdiction, and invite yourself if you have to, because all voices need to be heard. And as Houston in particular and their investigative reporters, if you follow them, you'll see that they've been doing amazing research to track all of the murders that have been happening when people are out on bond or on their own recognizance. They even are tracking how many days between posting bond on a prior case and when the homicide occurs. So I do think we're at a critical turning point. And as I've reviewed the law, the rights of victims have not changed. Yes, we're going through bail reform and jail reform for a lot of good reasons. And yes, we need to try to improve our system the best that we can. But the constitutional rights of victims to be safe and everything that is in the state constitution or under Marcy's law have not been revoked in any way. In fact, if you do this research, you find a whole string of what we call tombstone statutes across the United States based on victims who were murdered after an arrest was made, but bail hearing, either they did not have an opportunity to have a full-blown bail hearing where judges didn't get the information that they needed. So starting back in 2006, you have Ohio that passed Amy's Law, and that was a very good statute that essentially looks like one of our risk assessment tools in the statute with respect to bail. So Amy's Law passed in 2006 for a good reason. Amy was a victim who had been previously strangled, and her abuser was let out of jail before the judge even had a chance to conduct a bail hearing, and so the law changed there. Illinois passed Diane's Law under similar circumstances. Louisiana passed Gwen's Law in 2014. Virginia did something that I've been bragging about for years, because Virginia passed the first no bail presumption for stranglers. But unfortunately, and most recently, they decided to revoke it in the midst of all this bail and jail reform. And then Pennsylvania recently passed a law that allows judges to use a risk assessment tool focusing on victim safety. So on one hand, you have an elevation of offenders' rights, but on the other hand, you still have all of these laws that have been in place for many years and are still being passed to make sure that there is a balance. So we thought we'd ask a judge who is sitting as a court judge dealing with these issues all the time to just kind of reflect on where you are today with respect to bond, as you as a sitting judge are struggling through following the law, trying to deal with people who pose a danger to victims. So Judge Lee Chitwood, if you could join us now, we would love to hear your thoughts on the whole bail and bond reform issue.
Thank you, Gail. As Gail said, Virginia had a presumption that there were no conditions that could keep the public safe that would allow for release of someone who was charged with strangulation or other serious offenses. Well, unfortunately, as of July 1, all of our presumptions, including the strangulation presumption, are gone. I don't think this is going to affect my practice because, thanks to Gail and Casey, I understand the seriousness of strangulation. But in Virginia, most bond is set by the magistrate. So when a person's charged on a warrant, they go before a magistrate. The magistrate sets bond. So I am worried that folks charged with strangulation are going to be getting out on bond. Gail has trained in our community. We had magistrates attend that, so I think that will be helpful. But I want to talk just a little bit more broadly about bond in general. I want folks to understand I am absolutely for bail reform. We don't need to be holding people for misdemeanor possession of marijuana. We don't need to be holding people for petty larceny or trespassing. But let's be serious. $1,000 secured bond does not protect the public in any way. It simply means that a person is going to have to pay $100 to a bondsman to be released. So folks that can afford it are going to get out. Folks that can't afford it are going to be held. Again, it provides no protection whatsoever to the public. The focus should not be on the amount of money that you can post. The focus should be on dangerousness. Is this person before you a danger to the individual victim and a danger to the public? So some factors that I think we should look at, that I try to look at, is, does this person have a history of violence? Do they have a history of breaking court orders, especially breaking protective orders? I saw that in the chat. Somebody said that we should look at these violations of protective orders. I couldn't agree more. That's a person who has received a valid court order telling them to do or not do certain things, and they've chosen to ignore it. We need to look at, is this person under some form of legal restraint when they commit this offense? So they're already out on bond. Are they under pretrial services? Are they on some form of supervised probation or unsupervised probation? And we need to look at the nature of the particular offense that's in front of us. Do we have a lethality assessment? I have encouraged the prosecutors in my court to talk about a lethality assessment when we talk about bond. Most of the law enforcement officers in my community are trained to do a lethality assessment. Unfortunately, during COVID, they began doing it less and less. But I want to know if there was a lethality assessment, and I want to know if it says that this gentleman is a high risk to be released. And does the prosecutor have a good police report? Does he have something from the officer that explains what happens? Has the prosecutor talked to the victim, gotten the victim's version of what happened? There are occasions where if I don't have sufficient information, I will simply say, I cannot make a competent bond decision. I'll give you, Mr. Defendant, two choices. I can hold you without bond and you can appeal, or we can come back on another day when I have sufficient information and I can make a competent decision. But frankly, what I have been doing is either holding these folks without bond because they're dangerous, or letting them go on a PR bond. So again, I don't think I can emphasize enough that a small secured bond of $1,000, $2,000, $2,500, it helps the folks who let you out, the bail bondsman. It helps them, but it doesn't protect the victim. It does not in any way protect the public at large. So those are just some general considerations that I have with respect to bond.
Thank you, Judge. We really appreciate your comments, especially during this time. And I just want to add a couple of more key points as we continue. As we've been doing our research, we kind of went back to the late 1900s when California passed a law that specifically said that when it comes to batterers, that they pose a clear and present danger. To my knowledge, that has not been revoked. And that was something that Casey and others in California pursued in an effort to increase victim safety, enhance victim safety, and to hold offenders accountable. I wanted to share that in Nashville, Tennessee, they made it their point to make sure that they were included in those conversations when they talked about people who pose a danger, people who do harm, what's going to be included and what's not going to be included as they continue to have those discussions about bail reform and no cash bail. In the meantime, people are still dying, and I have an increasing sense of urgency to really talk about this issue so we could do even more to make sure victims stay alive. In February of 2020, the New York in Albany passed the Justice for Rachel Act because Rachel was killed by her ex-boyfriend shortly after he was released on bond for domestic violence. And then after he was arrested for her murder, he ends up getting released again. And it was only as a result of the family and the community being so outraged that they brought this back to their community's attention and fought for this act to pass that would bring back dangerousness back into the vocabulary of the courtroom and in bail hearings. Right now, Anaya's law for bail reform for victims is pending in Alabama. Sorry I didn't have a chance to double check to see where it is. The last time I checked, during COVID, a lot of these pending statutes were put on slow motion, but still alive. As I mentioned before, Texas does have a significant issue with respect to this and a lot of victims who are dying. And so pending in Texas, and anybody from Texas, you can let me know what is your current status of Caitlin's law, which is another example of yet another victim who died. And Delaware, as a result of the case that I just shared with you, has this bail reform bill pending to exclude those cases that have to do with guns, domestic violence, rape, and sexual abuse of children, so they will not be out on bond to get that cash bail, because exactly what the judge said, just because you can post your cash bail does not mean that victims are safe. And so this particular statute has already passed the Senate and it's on its way to the full House. But what I can also tell you is if you include animal abuse, for whatever reason, it seems like everyone is taking animal abuse very seriously. And from my tracking of these cases, it seems like animal abusers will get a higher bail. Animal abusers will be taken seriously, held accountable. They'll tend to get higher sentences and more supervision. So a couple of solutions, because we don't like to raise these issues and then not talk about the possible solutions. I forgot to put my video back on. Sorry about that. Solutions. Add the danger assessment to your reports, every kind of report. Generally, this is now best practice. It should be shared with other folks. You can ask the victim for her permission to share this information. Our experience, especially at family justice centers, when they come to your center for help, when they call the police, they generally want this information shared so everybody knows we're dealing with a high-risk victim. And now the research is very clear that if you're a strangled victim, you are, by definition, a high-risk victim. And after you identify that strangulation case, and if she separates, you're going to be dealing with that stalker. So as the judge pointed out, judicial education is key. All of us taking these cases very seriously, doing more to provide more information to everybody that needs to know about how high risk the situation is. Be that advocate for these conversations that occur at public safety, task force hearings, and different commissions being held throughout the state and in your county, bringing awareness to when good things happen and bad things so people can be informed. And I do want to brag about the Guilford Family Justice Center approach. because despite everyone's challenge in getting bail for people who pose a danger to the public and to the victim, our friends in Guilford County at their Family Justice Center, like many jurisdictions, have developed a high-risk team. And if you want to learn more about their high-risk response, I'd call Sonia Dese. There's her email address and also her phone number. But when they go to the bail hearing, they go as a we. They go as a team. You'll hear from Sonia, you will hear from the police department, you'll hear from the civil attorney, you will hear from other key partners who believe that this victim is at high risk. And the court appreciates that feedback and that knowledge in order to make, as the judge said, we need to be making informed, intelligent decisions. So now we want to shift gears a little bit and bring Judge Lee Chitwood back, because we want him to talk about a couple of tools that he has created to help him process all of this information in court and try to determine how he can follow the statutes, the protocols, and also his ethics as a judge.
Great. Thank you, Gail. As I mentioned, Gail has trained in my community twice, and this bench card grew out of that training. She came and trained about 115 of us, I believe. And a couple of days later, I had a case. It was a child protective order taken by our local Department of Social Services against an abuser who had strangled a woman. And they were seeking a child protective order against him. And the CPS attorney was asking questions, but I didn't feel like they were asking the right questions. I didn't feel like they were asking enough questions. So from my training from Gail, I started asking my own questions, but I felt unsatisfied with that as well, because I thought I was doing it in a very piecemeal fashion. So I sat down and began putting this bench card together so that I would have a resource in front of me when these cases come up. It may be a little bit hard for you to see this, but questions or parts 1 through 11 of this talk about Virginia law and talk about some of the characteristics of strangulation. As you can see, number 3 is now inaccurate because our bail section has changed. Then section number 12 is some of the questions that a judge may want to ask when these cases come before him. And obviously it does come up in criminal cases, but I have come up more in civil cases. Custody visitation, child protective orders, and of course, family abuse protective orders. Our Domestic Violence Commission in Virginia approved this, and then the Supreme Court distributed this to all Virginia trial judges in December of 2020. And through Gail and Casey's hard work, I think that this bench card is sort of catching on. Florida has approved one. I don't know if it's completely approved. Ohio is working on one. So I think it's a good tool, and I use it as a way. I know about strangulation. I feel like I know some about strangulation. There are a lot of judges who may not. And this is a way for them to have a quick reference to help them with that.
I would just like to add that we encourage Judge Lee Chitwood to share more information about his bench guide and card, and you can find him giving a presentation about 20 minutes if you want to share that with others on Facebook Live. It's on our Facebook page at the Training Institute on Strangulation Prevention. Go check it out and like us, because if you like us, I'm told that you will be notified about future things that are happening at our institute, like trainings, webinars, and when we release new tools. But we wanted Judge Lee Chitwood to also spend a little time talking about court considerations when petitioners ask to dissolve protection orders after a court has already made a finding that this particular person poses a risk to the victim.
Thank you, Gail. This bench card, unfortunately, it goes over the next couple of pages because it's lengthy. But this, I want to talk about this, and then I want to actually talk about a case I had this morning that really illustrates the importance of this. But as I said, this bench card grew out of my experience in court. What would happen is I'd have a victim come in, would describe horrific circumstance. I would enter a protective order, feel like I'm doing the right thing to protect this victim. 2 weeks later, a month later, she would come back and ask to dissolve it. And 10 years ago, 15 years ago, I would listen to some evidence, and of course the respondent sat there, didn't say anything. I'd listen to a little bit of evidence, I would grant the motion, I would dissolve the protective order, but I felt really horrible doing that, because you can't have someone who's strangled and beaten and all the horrible things that can happen and then come back a week or 2 weeks later and everything is fine at that point. So this began as a one-page checklist, and as I used it more and more, it's grown to several pages with multiple sections, multiple questions. Gail, if you want to just advance that maybe one slide for me, please. You can see some of the things I talk about are the current criminal matters. Is he out on bond? If he's been convicted and he had conditions, did he comply with those conditions? Question number 12 is I like to ask, why do you think this person is going to change without treatment? If they haven't been to a batterer's intervention class, what makes you think they're going to change? If there are children present, then I go through the section on children. And part of what I'm doing is, as I'm asking questions and gaining information, but I'm also trying to educate a little bit without being overreaching, but educate a little bit. Gail, if you'll go maybe forward one more, please. And I have an entire section on strangulation. You can see there's some things in red there. That's because this document I'm changing all the time. I add things, I take things away as it works. And you'll see in bold there, I ask, are you comfortable talking about this? I don't want to re-victimize these folks. You know, if they've gone through a horrible strangulation situation, I don't want them to have to describe it again and re-victimize them. So if they're not comfortable talking about it, then I don't force them to go through that. Can we go to the next one, please, Gail? And you can see I talk about weapons. I think weapons are something that are just not taken seriously enough in this work. And I talk about stalking, coercive behavior. Typically what happens is these folks will come back. I go through this, it takes 15 or 20 minutes. First go around, I pretty much deny all these motions to dissolve protective orders. Second go around, I may keep the protective order in place, but allow contact. I will never dissolve the protective order in full until I am convinced that the petitioner who got the protective order can be safe. I see a question in the chat. I'll be happy to share these bench cards with anybody that would like them. I'm going to share two quick examples. I don't want to tell too many war stories, but I had a lady come in last week. This gentleman was in jail, held without bond on 3 counts of violating protective orders. She came in, filed a motion, asked me to dissolve it. And I went through this with her. And one of the questions I ask is, the victim advocates are always in the courtroom. And I said, have you talked to these nice ladies who are in the back of the courtroom? She said, yes. And I said, would you like more time to speak with them? She said, yes. So I took a recess. She went out and talked to the advocates. She came back in and said she didn't want to go forward with her motion. So that made me feel like it was good. She was getting education and she was getting support. I wouldn't have granted her motion in any event. The other thing I wanted to talk about is I had a case this morning. A clerk for another county. I'm in a very rural area, and a clerk from another county texted me or emailed me and said, a lady has come in to dissolve her protective order. Will you sign the order dissolving it? And she sent me the order and just wanted me to dissolve it. And she intimated that the lady was there at the counter, needed to leave. Could I just sign that order and that'd be the end of it? And I said, hey, I'm not comfortable doing that. Send me the pleading, send me the affidavit, the protective order. And so I got the woman up on video and I started asking questions. One of the things I always ask is, did you fill out an affidavit when you got this protective order? And she had and I'm sorry this is disturbing, but this is what was in her affidavit. He beat me with a belt. He punched me in the sternum. He kneed me in the ribs on the left and right side. He kicked me in the right thigh. He threatened me if I leave, he would kill me and my family. Officer blank advised me to obtain a protective order. She filled that out on July 23. That was Friday. She came in today, July 26, asking to dissolve it. So I asked her a series of questions and I said, ma'am, has he physically abused you before? And she said, yes, 4 or 5 times a week over the last year. And I said, has he ever struck you with, outside of this, hitting you with a belt, has he ever struck you with another weapon? She said, yes, he took a blade off of a ceiling fan and struck me with it. So this went on for a little while, and I just said, ma'am, I'm sorry, but in good conscience, I cannot dissolve this protective order. A, I think you need to talk to an attorney, and B, you need to talk to an advocate, and you need to do some safety planning because you are in danger. So I hope I didn't exceed what my ethical role is. I wasn't trying to give her legal advice, but I did want her to understand how serious this was and that she is in danger and she needs to talk to a professional and get some help. So the final thing I'll say about this particular bench card is I developed this with the help of the advocates in my community. I got a draft together. I sent it to them. They pointed out some questions I should not ask or things I should change. So I didn't do it simply on my own. I wanted to make sure that the victim advocates were comfortable with it. And now when a person comes in and asks to dissolve a protective order, the advocate goes through this checklist with them ahead of time so they know what to anticipate. So Gail, that's what I wanted to say about those things. Thank you.
And this is the other page, or I think getting close to the last 2 key points on your checklist.
Yes, there may be a few additional questions, but you can see I do ask about pregnancy. I ask about weapons. I ask about animal abuse because that is very significant. I specifically ask about whether he's called you from jail to try to, during the honeymoon period, if he's called you from jail and either threatened you or promised to do certain things. If you want to go on to the next one, I think there's maybe one more page. And these are the final questions that I ask: has he done anything scary or frightening? Because as we all know, he may have done something that seems very benign to the public, but to this particular victim is terrifying because he knows how to terrify her. He may have just looked at her a certain way or driven by the house or done something that only she would know would be frightening. And the final question I ask is do you feel safe? So that's what it's all about, is safety. Thank you.
Thank you, Judge. And there are some questions that are coming up in the chat that we will save for the end, just to make sure that we give everybody time to address some of the key points that are coming up. And as Casey said, this was going to go really fast, and sure enough, he predicted it. Jim Henderson is not going to join us to talk about some risk assessment tools and some things that we can all consider, whether it's pretrial or a time of sentencing. Jim, thank you.
Great. Thank you, Gail. It's so refreshing to have family court judges like Judge Chitwood. So thank you so much for the work that you're doing. The interesting thing that he was just talking about is even the types of questions that he asked. And is a survivor or a victim even able to answer those questions? Or are they too terrifying? So if we can have these accurate and appropriate assessments done as quickly and as soon as possible, and then share those with other members of the criminal justice system and not always make a victim relive every single experience, that would be advantageous. 2 of the risk assessments that we've kind of liked early on that can be done from police officers at the time of an arrest or an investigation would be the LAP, which kind of grows out of all of Jacqueline Campbell's work, where she really looks at female femicide, right? So it's risk of lethality. How likely is it that this guy is going to commit a homicide, and what's the research tell us? Another one that we really liked was the Arizona Intimate Partner Risk Assessment. This one was created by Neil Websdale. It had 7 questions, and in the next slide, we'll see these questions really overlap. If we want to look beyond just to police officers. Some other assessment tools that we really like is Mosaic, who done by if any of you have ever read the book The Gift of Fear. If you haven't, I strongly encourage you to read it and to understand how women can be more in touch with their intuition and what that means. His tool is really neat in the sense that I can enter in all the data as a pretrial officer or as a probation officer, and it will actually type me up a report and tell me what those risk factors are and what they mean. The other type of assessment tool that's been gaining popularity lately in the criminal justice arena is a DVRNA. And that's really just, they pulled things together. They took information out of the danger assessment, they looked at the LSIR, they looked at ODERA, and they can put this stuff together and created what they look at as more risk, need, responsivity. What are the things that makes this particular offender dangerous? And if we address those things, can we reduce the likelihood? But going back to the things that we seem to see consistently through most of these accurate assessment tools are, is there possession of weapons, right? Because we know that most stranglers actually don't kill their partners through strangulation. We kill them with firearms, right? Strangulation is practice. Strangulation is where I can send her a message and make sure she gets it. I could kill you at any time, and lets me feel the power of having her life in my hands. And so that's why Gail constantly refers to it as a last warning shot. It's like saying, hey, people, he's telling you I am a killer and I'm going full blast ahead. The other one was stretch to kill. Obviously, if I'm strangling you, that was my message, right? I could kill you. This is not meant to be funny, right? Access to guns. Has he ever tried to choke you? Jealousy, separation. Now you think about separation, sometimes those are court mandated separations. But if this offender feels that this person has a potential to leave him and he not have that power, he may be willing to go to the next level. So really kind of looking, and then is this offender stalking the individual? We can go on to the next slide, Gail. So if you look at Jacqueline Campbell, she kind of reduced it down. She started off with a 21, then she kind of went down to her top 5. And these are things that can be done fairly simple, fairly quickly by the police officers at the scene of the crime, can also be done with advocates with the victim. And has the physical violence increased in intensity or frequency over time? And we know that there is progression. If an offender is telling you, or a victim is telling you, this is the first time he's ever been violent to me, and he went to strangulation, that should be very questionable. It'd be like the very first time I ever did drugs, I chose to shoot up heroin. Usually we would start with a much lower level of drug. I maybe smoked pot, did some speed, did some other things, and I worked my way up. Same thing with men who strangle. We started off with slapping, hitting, threatening, pushing, punching. And now as things get worse and worse and worse, we're doing the most lethal form of violence other than shooting you. Has he used a weapon against you or threatened to use a weapon? Right? Do you believe that he is capable of killing you? This is the interesting one. What Jacqueline said, that almost trumps everything. If she believes he is eligible and capable of killing her, we need to take that very seriously. Many victims, however, will underreport that. Think about this for a minute. When you think about your hypothalamus, and you think about, our parasympathetic nervous system, if I'm on high alert all the time, I'm not going to be able to function. And so part of my mechanisms is to kind of deny that reality, deny the danger that I'm in. It makes me, I compartmentalize what happened. I kind of make excuses for it. I kind of have the best hopeful intentions it's going to happen in the future. And so a lot of people don't really recognize the danger that they're in. So just because I say he's not capable or it wouldn't happen, does not mean that that's true. But if I say it is possible and I believe that he'll kill me, take that very seriously. Do the right type of safety planning with me. Make sure I'm connected with all the resources our community has. A good, well-trained victim advocate, good victim services. If you don't have that in your community, build it and resource it out, right? Who else can we talk to on a national level if we don't have anything in our backyard? Has he ever choked you, and is he jealous of you? So again, same types of questions that we're seeing throughout these. The other thing I want to say about assessment tools, we've really misled our community, because we'll say that we're doing a safety assessment. And many people, what a safety assessment means at pretrial level is just an assessment on if he's likely to return to court or not. So we're looking at most of these men who strangle, If I strangle my wife, we probably live in this community. I probably work in this community. I probably have ties in this community, which would put me low risk for fleeing, right? And so you're telling the community you're doing a safety assessment. I'm getting a good score that's being presented to the judge. Jim has a high likelihood of returning to court. He's low risk, but you're not looking at risk of ongoing danger or risk of lethality. So we really want to consider and look at that and make sure that we're on the same page. And we know that the tools that we're doing are looking at strangulation, are looking at firearms, are looking at separation, are taking all those things in consideration. Do I have a drug addiction? Am I actively using? Am I actively drinking? Do I have mental health issues I'm not taking care of? Am I employed? We know that unemployment also dramatically increases lethality. And over COVID, many of us are not employed. Many of us have increased our use of drugs or alcohol. And so women are in a much more dangerous situation than they were pre-COVID, I think. For sentencing recommendations, there's a variety of things here. You got to think about everything you do is watched and interpreted by the offender, by the victim, and by our community. We're constantly sending a message through my actions and inactions. Do I send a message that what my sentencing is about protecting the community, right? Am I saying this guy is a danger to his wife, he's a danger to his children? We see that when Gail was looking through those articles of men who've actually killed someone out on pre-trial or on monitoring, some of those men had actually, one guy had actually strangled a woman. She actually died but lived. They brought her back. He was out on bail on that, chased and strangled another person, got let out. And the next time he went out, he went back and killed the first person. He should have never been out for the first person. So we're not protecting society. Are we punishing the defendant? So you can look at these focused deterrents, right? For some men, a deterrent works, right? That the threat of going to jail matters. If I feel you are all I have and I'm losing you, the punishment and the deterrent is not going to work. All you can do is try to lock me up long enough for my partner to get secured housing, to create a safe environment for herself, to start her life over and to heal, right? And then try to give me some type of rehabilitation while I'm incarcerated. Make sure that I'm getting job training, make sure I'm dealing with all the traumas that happened in my life that made it justifiable for me to use that extreme types of violence. We obviously encourage rehabilitation, although not all men want to be rehabilitated, right? We have some good programs in the country and we're getting better and better all the time. We're doing better research. We're now looking at trauma significantly more than we ever used to. But I can go through the very best program in the country and have the best probation department and the best police department in my community. If I don't want to change, you're not going to make that happen. And so you really need to look at the research that says men who don't complete treatment, men who drop out of treatment are significantly more likely to go back and continue the behavior that they're doing. So if you give me a chance for rehabilitation, the minute I miss a class, I should be back in front of you in court and I should be getting sanctions and consequences for that. My judge would say, if it was me, she'd say, Mr. Henderson, when you came to court, you swore to me that you regretted the behavior that you did to Mrs. Henderson and that you were going to change and address that. I gave you an opportunity to do that, released you from jail early, allowed you to do this intervention program, and now I hear you skipped group Monday. How am I to know that my community is safe, that the children and women in my community are safe if you won't even do the bare minimum that you promised this court you would do? You've left me no other choice but to return you back to jail. So she sent him a really clear message that this was about accountability, this was about safety, and then the victim sitting there in court knows this judge has my back. Right? This prosecutor has my back. Much more likely that victim is going to engage our system in the future when she or he knows we're there to protect them. We want to deter that future violence. So if you know that people are being held accountable, there's no reason for you to change your behavior, right? During COVID, they weren't giving anybody any tickets for not having insurance. Nobody, lots of people never bothered getting insurance. You didn't need to. If I know they're going to release me from jail and I'm not going to get incarcerated or I'm not going to get found guilty or I'm not going to get prosecuted, why change my behavior? If choking you gets me what I want, makes me feel power, makes me feel like I can get you to obey me, get you to do what I want you to do or stop what I don't want you to do, all of that is rewards that I'm getting. Reward, reward, reward. And if there's no type of consequences, why should I change my behavior? I'm not going to look at that. All right. Restitution, really important to look at this one. We often fail victims here. We might say, okay, you knocked out my teeth, so you might pay for my teeth. He ripped my blouse. You might have to pay for my blouse. But what about the long-term consequences of strangulation, right? The more we're looking at, many victims were not strangled one time. There's a pattern of strangulation, right? Many times when people are strangled, their heads being hit against the wall or the floor, or just that constant shutting off of the blood flow and airflow is causing some damage to the brain that may have longitudinal problems, right? Are we assessing that? Are we ordering that in court? And how much flexibility do you have? I know when I was in Ann Arbor and we were worried about ongoing medical treatment, the judge would say that, that she left it more open-ended on what we could do with restitution, because we wanted to make sure that we were able to help victims with the services that we need. But we've ordered an offender to pay for the lease to be broken, pay for new security deposit, pay for cameras to be put up in the home, a variety of things, so this victim could feel safe after being so traumatized by that individual. We want some type of uniformity in sentencing. If it's kind of hit and miss, depending on if I get a great attorney or I get a crappy attorney, if I get the court-appointed attorney or the most expensive guy in town, we're not, again, not going to have people participating in our criminal justice system. And it leaves men an opportunity to be resentful at the system and blame us instead of looking at themselves. And what we want to do is erase any sign of sexism, racism, classism, all that kind of stuff. And we want to say, you know what? We value the lives of the people in our community. We do not accept this behavior in this community. We love you and we will support you in change, but we will not tolerate this behavior anymore. If you do this, these are your consequences. And you can do this much right now. And once you get out of prison and you get out of jail, you're going to do this to prove that you're willing to change and address those issues that allowed you to do that behavior. And if you're not, you tie our hands where we have no other choice than to go ahead and incarcerate you for the full length of time. Next slide. So we can look at some of the statutes, and even these well-meaning statutes, they could be enhanced a little bit. So let's look at Massachusetts. They require batterers intervention programs to be completed. But do we have a one-size-fits-all batterers intervention program? As we're looking at risk, need, responsivity nowadays, we're starting to look at the more lethal men should have more intensive intervention than the guy who pushed and slapped and called his wife the B word. We're not saying that that guy should get a slap on the hand. We're saying he needs to be held accountable as quickly as possible so he doesn't get up here. But if I'm willing to put my hands around your throat, maybe my treatment, my intervention should be more rigid and more a broader spectrum of behaviors. You should really look at the trauma that I experienced. You should look at my other criminogenic needs, make sure I have employment, and really do more wraparound services. We're seeing that actually happen around the country, much like a family justice center. You have the Gateway Initiative out of Maryland, where they're trying to do wraparound services. They're assessing these men, looking at what other needs do they have that relate to their criminogenic needs. And their research has showed a significant reduction in ongoing violence with these men when we've actually done this wraparound services. The other thing that they found that contributed, the highest likelihood of repeat offense was a lack of hope. That these men felt that because of the structural racism, because of the oppression in their community, because of all the other issues that they had, that they could not see a better day for them tomorrow. And so really rebuilding hope in people is so imperative as well. West Virginia, right? They're looking at not less than a year, not more than 5 years. Mississippi, and we're seeing longer statutes now and getting longer times of incarceration. My only suggestion would be jail in itself is not going to fix me. It actually may make me an angrier, more violent person when I get out. In fact, sometimes when I get out, I'm now homeless. I don't have a job. I haven't dealt with my addictions. I go back to using. And so a victim may be more terrified of me than ever. I would be careful about maxing out the time on people unless that's what the victim wants, but really looking at if there's any way to monitor and encourage rehabilitation. I know for us, we were doing extensive batterers intervention with men at a misdemeanor level for domestic violence. But our most violent offenders were going to jail for the maximum time and getting no intervention. And we kind of scratched our head and said, that makes no sense, right? Low risk guys get all of this work. And we think good work. We think they're doing some good stuff in those programs. But the guy who's most likely to kill her, we just lock up and forget about. And so we actually wrote a grant and created a batterers intervention program in our jail. And we called it a batterers preparation program, batter intervention preparation program. So much like if you weren't great at English or math and you could get into a college, maybe they said, okay, the first year you're on probation and you got to do these college prep courses while you're here, right? So we're saying, let's make yourself eligible to do a program on the outside. And homeless shelter, finding a lot of women who didn't trust the system for various reasons, but yet these predatory men who are at the shelter were engaging and targeting women. And so the shelter created a policy and created a program there that if men were engaging in predatory behavior, they can be ordered to this class that was paid for. Other court considerations, we don't want to see cases diverted, right? Too often that sends a wrong message. The research out of Minnesota, when they did the watch program, 89% of the men who re-strangled within 2 years after getting out of prison were after conviction were men who weren't held accountable. Their cases were diverted. Nothing happened to them. We got to make sure we're not doing that. Insist that the man take some ownership for what he did. We were going to show a video, but we didn't quite have the time of the case that happened in Alaska, where the man had strangled a Native woman, told her he was going to kill her. When she lost consciousness, he masturbated on her. When in sentencing, he never addressed the trauma that he did to the victim, the trauma that he did to the Native American community. All he did was thank the judge for giving him an opportunity to restore his family and to be the good father that he is. Never took ownership for anything and was not held accountable and not held in jail. We want these guys to admit what they did, take ownership for it in a court, and acknowledge the damage that they caused. Pay close attention again to restitution. And I can't say that enough. Just looking at what are we doing for ongoing medical expenses and what are we doing for restitution that could actually make this person feel safer in their own home, and can we do that? How flexible are you willing to be? But we know that some of the men, while they're on supervision, are still committing horrible crimes, and we know that people who are calling the police again and again and again, and nothing's happening, these men are going back and committing murders. So we have to do a better job at doing better supervision, watching these men. I think there should be multiple pathways for victims to get help. I love the fact that family courts are getting involved now and requiring intervention, maybe even doing judicial monitoring from the bench in family cases, divorce cases, child custody cases. Just amazing work there. And this is kind of, we were talking about bench cards earlier, and I know you can't read this very well, but this is something they've been working with Ohio. Gail, can you go to the next one? We took a little piece of that out, and I know this is a little blurry, but what I really like about this part of the bench card, it gives you kind of things to consider with the offender. But I really like this one, things to consider when working with the victim, right? Evidence of vulnerability. Is she really vulnerable? And is there anything our system could do to reduce that vulnerability? And I read in one of the messages, someone talked about victims not having any resources, right? And if he's paying the house payment and he's paying for my health care and he's paying for my child's health care, and you lock him up and I think I'm going to lose everything and I have no support, I might try to think, okay, he strangled me, but I'm still alive. I lived through it. If I'm homeless, if my kid has no Medicaid, I might not be alive, and they're not going to participate. We got to do a better job of looking what we can do. What are the issues going on with the victim? What's her dependency status? Is she an immigrant? What's her immigration status? Can we help with that? Is she pregnant? What's going on? It just has a variety of things that we can really look at. Go ahead and go to the next slide. And
I'm going to invite Casey to jump in. So thank you, Jim, for covering some of the key points. This could be, we've talked about this could be a day-long session just on court considerations. Casey?
Well, thanks, Jim. Thanks for participating in this. And thanks, my friend, for all the work you do. We're going to continue to be available. And Jim, of course, does a great deal of consulting and training for probation, parole, for court systems around the country, and is always available as a resource. We do think that this whole dialogue around understanding what happens to survivors, particularly survivors of strangulation assault, but really survivors of all intimate partner violence when they get manipulated or intimidated, is very significant. One of the best articles you will ever read is called Meet Me at the Hill, Where We Used to Park. It is an amazing article studying the impact of jail calls when offenders get arrested and then call their victims from jail. And if you have never read this article or studied the research that came out of this article, looking at hundreds of jail calls and the pattern that perpetrators use in order to manipulate their victims into minimizing, rationalizing, not wanting to testify in court, not being willing to engage with the system, recanting their story. Out of that research even came a recantation wheel in 2011, very not dissimilar to the power and control wheel, but this wheel is really focused on the exact process that perpetrators commit when they go through the jail calls that they make that kind of start with, oh baby, I love you, I'm never going to do it again, I'm so sorry, to you don't want to do this, you don't want to, it's us, it's you and me against the world, baby. You don't want to let them destroy us, to if you call the police, if you testify, you're going to answer to me, you'll never see your kids again, and so it goes. And that emphasis on how terrified the victim gets is so important. There you see those stages. Whenever we talk about strangulation cases, remember this one statement: 100% of strangulation cases involve intimidation. 100%. So even though this amazing study out of Ohio and Washington was not particularly focused on strangulation, you can magnify the impacts of all of that when you see what happens when victims begin to recant, as Judge Chitwood talked about, when we see victims begin to minimize or to rationalize. And long ago and far away, almost 15 years ago now, the Supreme Court of the United States said domestic violence cases are notoriously susceptible to intimidation or coercion of the victim to ensure that she does not testify at trial. And you can, again, put that on steroids when you're talking about strangulation assault, because you're talking about a man who has just taken a woman to within seconds of death. And he has made very clear that he is God, and he will decide whether she lives or dies. And don't be deceived. He's been able to do that in many cases without any visible injuries at all. You can strangle someone to death with no visible injuries, which means you can strangle them almost to death with no external visible injuries. So that dynamic of intimidation, so crucial in understanding the dynamics of these cases, particularly when we're talking about advocacy and the importance of advocacy. I know we're actually coming to the end of an hour and a half. It's very hard to believe. I will just fly here, Gail, unless you want to jump back in, but we've got great resources. We've got great webinars on our website. Gail loves that phrase, do more. We have a great acronym there about things that advocates should be doing, things that advocates can provide. Bottom line in that is survivors need to understand how life and death this is. Survivors need to understand the need for medical attention, because many survivors are suffering traumatic brain injuries. They're suffering internal injuries that may even lead later to stroke or death, and they have no idea. They think even if he takes them to unconsciousness that they're going to be fine. Go to our resource library, go to strangulationtraininginstitute.org and click on the resource library, and you can find all of these resources on our resource library. Survivors need advocates to explain to them that this really does mean he's more likely to kill her. It's very likely that she's at risk for brain injury or stroke, and she may have absolutely no idea. It's very critical that she get a forensic medical exam. Very critical that she understand how different this conduct is from the pusher, the slapper, the shover. The man who slaps or pushes a woman is an asshole. The man who strangles a woman is a killer. They're not the same. He may push, slap, shove, kick, and strangle, but if he just is a pusher and a slapper, it is highly unlikely that you're going to find out that he's the killer. It is about neck compression. That's what shoots everything up on the danger assessment. That's what shoots things up in Mosaic. And don't forget that when stranglers leave, they become stalkers. When the victim gets away from a strangler, he's most likely to become a domestic violence stalker. That's why Mosaic is so important, because Mosaic method covers all kinds of domestic violence, but it picks up that stalking piece in domestic violence that is such a high grade marker for lethality. Hopeful things to say. I'm so sorry this happened to you. You didn't deserve this. We're here to help you whenever you need the help. I'd love to know everything that happened. It's okay to tell me what happened. We so always want to shut down the victim when she starts giving us context. I just need the facts, ma'am, just the facts. You will fail strangulation assault victims every time with that kind of an approach. Context matters, as Judge Chitwood said, so we understand later that look or that one piece of action or that piece of paper he leaves for her or something he does, so we realize how significant it is. And we've got to continue to advocate for victims' rights. In the world of criminal justice reform and bail reform, do not forget Marsy's Law. Do not forget the rights of victims. They should not be shunted aside simply because we're going to listen to, let's stop arresting everybody. Let's stop prosecuting everybody. Let's let everybody out of jail or prison. We don't want people to stay in jail because of COVID. Let's remember the rights of victims on so many of these topics, including, by the way, just recently, the federal law that changed that doesn't require absolute victim participation or cooperation with law enforcement anymore, because terrified victims aren't going to always cooperate with law enforcement, but they should still have a right to compensation. Long-term injuries mean they also have a right to a civil suit against their perpetrator. I'm in the middle of one of those as we speak in San Diego, suing a strangler and his lawyer, by the way, for their misconduct. Restitution is a right. Victims may have long-term health issues that need to be addressed much later. So this victim restitution process is not a one and done kind of a process. It's got to be acknowledged that injuries may come out over time. The long-term disability may become evident over time. And advocates certainly are the ones to keep raising this issue. Don't forget, victims have a right, whether they have the money or not, to receive services in hospitals. If you hear that local hospitals are sending victims away, tell us, contact us. It's what's called an EMTALA violation. They cannot send them away. Strangulation is an emergency medical condition. If she needs medical attention, they can't say, hey, she doesn't have the insurance for an imaging, for radiographic imaging. She deserves and has a legal right to it, and hospitals don't get to say your insurance is inadequate, or we're not going to do a CTA because she's poor, or she doesn't have adequate insurance. When we're talking about something that is a serious impairment to bodily function, we're talking about the rights of victims to be assessed and treated for those injuries. And hospitals have a legal requirement to do that. They do not get to send her away. It is a violation of federal law that subjects hospitals to major civil liability if you in fact find out that that's happening. I do want to thank Angela Maudlin, who's one of many advocates that's gone through our training, who raised this issue for us and says, you know what, don't forget to mention EMTALA because this is a real thing. If survivors start telling you that a hospital or a doctor is refusing to do assessment and treatment because she has inadequate insurance, call us, email us. We are actually beginning to look for cases across the country where we can hold medical providers accountable for violations of federal law. We like victim impact statements at the beginning of the case, in the middle of the case, at the end of the case. Don't wait till the end. Ask the victim at the beginning what this has done to her, how it's made her feel, what she's struggling with. Ask her at the beginning, not at the end. So often prosecutors and system-based advocates wait till the end of the case. Please don't do that. Do that at the beginning of the case. It also will help the victim understand what's going on and what they're experiencing in ways that they may not otherwise understand. We are coming to the finish line here, friends, but I will tell you that in our research, it is very clear that of all victims of domestic violence, the ones most robbed of hope are those who have been strangled. In fact, Dr. Chan Hellman and I have published research now on this out of our National Polyvictimization Initiative, that strangulation is the ultimate robber of hope. Lowest hope scores on those who have had somebody put their hands around their neck, because in that moment, you lose all ability to imagine who you want to be in life, what you want to do. The very definition of hope is looking forward and setting goals about who you want to be, what you want to do. Strangulation victims of all survivors, highest rate of suicidal ideation. So remember, when she talks about suicide, that is a natural consequence. She's talking about being trauma informed, or trauma responsive. That's a natural reaction to being strangled. The man who claims he loves her is on top of her, and he is deciding in seconds whether she lives or dies. The ultimate robbery of hope. So we've got to help survivors understand that, and we've got to be able to dialogue with them. We do provide enormous resources around the science of hope. The incredible importance of increasing hope again, or restoring hope in the lives of both adults and children. Been honored to write 2 books on the adverse childhood experiences study in the last 5 years. The most recent book is hitting bestseller lists all over the country, Hope Rising, How the Science of Hope Can Change Your Life, with Dr. Chan Hellman, the director of the Hope Research Center. We don't have time to talk about it today, but if you don't start talking to survivors and help them understand why they've been robbed of hope, and why they're struggling with their future, and why it's so hard for them to look forward in life, you will fail. You'll fail as a doctor, a nurse, an advocate, a prosecutor, because they're having normal reactions to an incredibly terrifying, difficult experience. And remember, if it's happened over and over and over again, they're probably suffering brain injury in that process. And that brain injury makes it even more difficult to navigate your life and look forward because of everything that's happened to you in the past. So we have come to the finish line, really, in this webinar today. If you want to know more about this, if you want to keep track of our future courses from the Training Institute on Strangulation Prevention, all you got to do is grab your phone there, and you can text the word Hope Giver to, as if it was the phone number, 22828. And then you can be on our mailing list. We have upcoming courses, 4-day courses, 1-day courses on strangulation assault. But we wanted you to have a little sense of the complexity of these issues in the court setting. That's why we asked Judge Chitwood to join us, because he's living this every day. That's why we asked Jim Henderson to join us. The first Wednesday of every month, we have a sneak peek of the week from the Institute on Facebook. You can go to the Training Institute on Strangulation Prevention Facebook page. We talk about these issues. Our big course will still be virtual in October. Registration is open as we speak. Go to strangulationtraininginstitute.com for information about that course. It's just about full, but we welcome you to dive deeper. This is just a little introduction to these issues that are so important. But courts are failing survivors of near and non-fatal strangulation assault across America right now. And so we're doing everything we can, as I said, to offer 1-day courses, 2-day courses. We're flying to communities across America and around the world to provide this information as well. Survivors deserve better, and survivors deserve a lot more information than they're getting, and they deserve better trained professionals. And finally, we're working on our newest course called Getting Away with Murder, because we believe that we have victims who are dying of strangulation assaults, and then their perpetrators are staging the scenes as accidents or suicides. And we believe law enforcement is getting fooled. We have about 7 cases we've worked on so far that are clearly murders. And law enforcement got fooled because that sophisticated strangler knows how to play the game. And he staged the scene, and law enforcement got fooled, particularly if drugs or alcohol are involved. They get fooled. So stay tuned for that course, because we believe that this is a crucial course that we need to host next year in this country. So thank you all for joining us. You can always reach out to us in social media or on one of our websites. Gail and I are passionately committed to doing everything we can to provide these resources, and we so appreciate the U.S. Department of Justice Office on Violence Against Women. There's some email contacts for each of us, including Judge Chitwood, and you can sure reach out to any of us at any time. It is not our intent in any of this to make this seem simple. It is not our intent to minimize the importance of criminal justice reform. It's not our intent to minimize the significance of the need for addressing systemic and structural racism, which is incredibly real. and disparate impacts on communities of color, which is incredibly real in the criminal justice system. But if we simply throw everything aside and, let's say, abolish it all and start over again, we will continue to see this rise in homicides, and we will continue to see the rights of victims ignored. And that we will not stand for. We will die on that hill of advocating for the rights of survivors of violence and abuse and talking about what they're facing in systems. The answer is not to throw away the system. The answer is to do much, much, much better in addressing these issues. So blessings on all of you. Please feel free to reach out if you need us. Thank you to Gail Strack and Judge Lee Chitwood and Jim Henderson. Thank you, Grace, on our team for hosting this. Blessings on all of you in your work. As Mother Teresa said many years ago, you must give hope, always hope. And it's my earnest prayer that we have done that today. God bless you all.